Welcome to Employment Law This Week. I'm George Whipple. Our top story, New York City introduces Me Too legislation. The City Council has introduced a package of bills modifying sexual harassment laws. One would require private employers with at least 15 employees to implement annual sexual harassment training. The laws could add significant and costly requirements, particularly for smaller businesses. Carleton Schaefer has more.
First, the law would mandate that private sector employers here in New York City who have 15 or more employees conduct annual anti-harassment training for the entirety of their workforce commencing in September of 2018. Second, the law would expand coverage of the New York City human rights law to smaller employers, to employers who have fewer than 4 employees. And finally, the law would lengthen the statute of limitations period, the time at which people can bring forward claims of harassment, which is currently at 1 year, to a period of 3 years. This package of legislation, which is comprised of 11 separate bills, which collectively is known as the Stop Sexual Harassment in New York City Act, would have a profound impact on nearly every single employer in New York City, and there are about 270,000 private sector employers.
The Sixth Circuit rules that Title VII covers gender identity. The EEOC sued a Michigan funeral home for firing its director after learning she planned to transition from male to female. The employer claimed protection under the Religious Freedom Restoration Act. The federal district court agreed, but a panel for the Sixth Circuit found that firing the plaintiff due to her transgender status was unlawful discrimination on the basis of her sex. The court also held that enforcing Title VII did not substantially burden the employer's religious exercise. This is the second federal appellate court in recent weeks to have sided with the EEOC's interpretation of sex under Title VII. And more from the Sixth Circuit. The court ruled that a nurse who claims she quit her job rather than participate in fraud can proceed with a False Claims Act lawsuit alleging constructive discharge. The district court dismissed her suit, holding that such a claim requires the employer to have specific intention to cause the employee to quit. The Sixth Circuit reversed and concluded that an employer's intent can support a constructive discharge claim if it can reasonably foresee that the plaintiff might be forced to resign as a consequence of its actions. A nursing assistant gets sick over a county flu shot policy. An employee at a Wisconsin nursing home claims that she was forced to get a flu shot despite her religious objections. The county policy required a written statement from a clergy member in order to get a religious exemption. The employee was not affiliated with the church and provided a letter she'd written herself. She was forced to get the shot to avoid termination. After she filed an EEOC complaint, the agency referred the case to the Justice Department, which has now filed a Title VII suit claiming that the county's policy fails to reasonably accommodate religious beliefs. And that brings us to our tip of the week. Russ Ebersole, General Manager for King Cole Audiovisual Services, is here with advice for small employers on keeping up and complying with employment laws in the current environment.
In 2017, countless new employment laws were enacted in New York State, California, Illinois, and many other jurisdictions. These include wage and hour, family leave and sick time policies, scheduling requirements, tax levies, and more. Small businesses are not exempt, and keeping abreast of these changes can be a daunting task. We must become familiar with these laws and regulations, and we must also develop policies and procedures for proper implementation. Failure to comply can be costly. So how do we stay on top of it all? Review the advisories and other resources sent by outside counsel like Epstein Becker Green. Seek additional resources such as state and local government websites. Sign up for their mailing lists so you receive timely updates directly from the source. For example, Governor Cuomo's office releases many of these advisories in New York.
Thanks, Russ. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.